I appreciate that, but I think it's time that he gets a taste of something else because I just can't with that history. In accordance with the laws of the state of Nevada, this court...
Remember that video well. Defendant Deobra Redden was in court last January to be sentenced for attempted battery.
But while the judge was talking, Redden ran and flew over the bench, attacking the judge and knocking her to the floor before he could be pulled off of her.
Today, as jury selection was getting underway, the defendant pleaded guilty to 6 of 7 counts. The remaining count of attempted murder, however, remains.
And jury selection has now begun. Court TV anchor Ted Rowlands catches us up on the case.
On January 3rd of this year, Deobra Redden leapt and tackled Judge Mary Kay Holthus. He was in court for sentencing for a probation violation connected to an attempted battery charge, which stemmed from allegations that he had attacked somebody with a baseball bat the year before. Moments before the courtroom attack, Redden asked to stay on probation instead of being sent to prison.
Based on my criminal history, I feel that I shouldn't be sent to prison for a second time.
Have you looked at your criminal history?
Holthus did not like his criminal history.
3 felonies, a gross, 9 misdemeanors, multiple DVs.
I'm in a better place in my mind, my mental health. I have a support system. I just got hired as a teamster for, the union.
After stating his case for leniency, Holthus began to sentence him to prison.
I think it's time that he gets a taste of something else because I just can't with that history. In accordance with the laws of the state of Nevada, this court...
According to court documents, Redden punched Judge Holthus in the head and pulled her hair, and he punched a corrections officer multiple times and spit in another person's face. The court marshal, who ran to help Holthus, tripped as he tried to detain Redden, dislocating his shoulder and cutting his forehead, requiring 25 stitches. Redden is now facing a slew of new charges, including attempted murder, battery on a protected person, and battery on an officer. He invoked his right to a speedy trial and has pled not guilty.
He's also pleading not guilty based upon reason of insanity. Just like everybody else, and looking at the video, I thought Mr. Redden was either out of his mind or on drugs at the time of this incident. But after extended discussions with Mr. Redden, Ms. Springer, and other family members, I came to find out that he suffered from severe paranoid schizophrenia.
Redden ended up appearing in front of Holthus one more time to finish the sentencing hearing.
I am making my calendar page from that day an exhibit for the court. Nothing's been changed, indicating the sentence I intended to impose.
Redden was sentenced to 19 to 48 months in prison, but now he could face decades behind bars.
You know, good for that judge for getting right back on that bench and being in front of him.
Yeah.
It was important to do that. I'm glad she did.
I was just thinking the same thing. That I was like, man, that takes a lot to get attacked and then say, okay, let's keep going, bring him back out.
Yeah, no doubt about it. All right, still with us, trial and civil attorney and law professor Dante Mills. Dante, the defense on their own, this was not something negotiated with the prosecution, decided to plea to 5 of the 6 charges, or 6 of the 7, I can't remember.
2 through 7.
2 through 7, so
5.
5 of the 6, including things like battery, intimidating a public officer, wanton disregard for safety, those types of things. Why might they have made that choice?
I think it's the right choice. I don't know if there's much wiggle room here. It was caught on video, and I do, just as you guys did, the judge deserves a lot of credit for getting back up there. And also something that's worth noting, she said that she put her calendar from the day of the sentencing when he attacked her into evidence, which showed she had written down what sentence he was going to receive. That's very, very honorable of this judge, because she could have not put that in and then sentenced him to the max time because she had this in her mind, but it wasn't the right thing to do because his sentence for the prior case should have only dealt with the prior case. And she made that clear. I think that was very honorable. Now we move forward. I think the defendants know he's in trouble. I do think that murder charge is a little excessive, but the rest of the charges I think are appropriate, and rightfully so. The defendant in this case made the right move by pleading guilty, and I think that's the right call.
Let's talk a little bit more about the murder charge and the intent that would be required. We know, we just heard his attorney say, rather, paranoid schizophrenic. How does that play into a defense saying intentional murder, this was not, or attempted murder?
I don't know if it's going to hinge on that. It would more hinge on, he punched her. He did dive over. He punched her. I don't know if that meets the standard for attempted murder. There was no weapon used. Maybe if he strangled her or got the, thankfully he did not get an opportunity to strangle her. You don't know if that was his intentions or not, but he didn't. Throwing a punch, I don't know, meets the standard for attempted murder. And I understand that you want to protect judges, but there's a charge for that, right? Assault of a protected person. So you can't overcharge just because of the facts when there's charges in place that protects our judges as they should be protected, and also protects the officers. And the officer was hurt in the midst of responding to it, and that charge is adequate as well, and I think appropriate. But I think the murder charge goes a little bit too far.
So let's talk about why prosecutors decided and how they're going to support that. At the end of the day, if you're talking about attempted murder, you're going to need some sort of intent or some kind of action that was so a disregard for safety or for human life. Where are they going to get that from? Is it the idea, because one can clearly say, if left to his own devices, no one stops him, he might have killed her.
Yeah,
I don't think anything would have stopped him.
Right.
So if that's the case, is that enough? You make that argument to the jury. Is that enough to get to that attempted murder?
I don't think it is, because how do you show what somebody might have done? There are some crimes that take planning, but clearly this wasn't planned. So it's not like they can point to something where he said, I'm going to go kill this judge, or a diary where he wrote, I'm going to go kill this judge. This was clearly something he did in the moment. And if he did not strangle her or take any of those actions, how do you say, if we didn't respond to him, he would have? I don't think that can be proven beyond a reasonable doubt, because if I'm his attorney, I'm arguing, no, he was upset, he punched her, and that was it. And how do you prove otherwise? That's the issue. They may look at maybe the dive and say it was so dangerous that his weight coming, they may bring in a doctor to talk about his weight or something like that, that may make the dive more dangerous than an assault. But I think they have a hard time showing and proving that charge beyond a reasonable doubt. I wouldn't be surprised if they allow that plea, that negotiated plea, to move forward, and that be the end of the case.
All right, what about the fact that there was a plea of not guilty by reason of insanity, according to the attorney? What does that mean?
It was interesting because the attorney talked about when he watched it, he thought, man, this guy is either crazy or on drugs. We know that on drugs, being on drugs is not, and I think the attorney said out of his mind, but being on drugs is not an excuse. You cannot get an insanity plea for if you voluntarily took drugs or if you're intoxicated, but that wasn't the case here regardless. If they can show that there's some kind of history where he received treatment, where he may have had some spells of this before, maybe, but it's hard if you don't have that to say, oh, for this one moment, he was insane, but every other moment, he was okay. You can't do that. That doesn't hold up in court as a defense. So if they're going to move forward with that defense, they're going to have to point to some specific instances in his past, and I would say recent past, where he's had similar behavior in order to prove that this behavior was because he was insane.
Yeah, and I think the direction the defense is going is they're claiming he was supposed to be on medication for the diagnosed paranoid schizophrenia, and he wasn't on that medication. The problem is he seemed very coherent leading up to it. As a matter of fact, he had just finished telling the judge, I've been in a really good place.
And it was a really well-said argument that he made, so I would agree with that.